Hello, and welcome to Dorsey's International Real Estate Podcast. I'm your host, as well as your guide, Fred Dorsey. Please be sure to like, follow, and subscribe to @Dorsey's Realty on Facebook, LinkedIn, Instagram, YouTube. And you can even subscribe to our newsletter, which can be found on the web at dorseysrealty.com. Hello. Thank you for joining this week's podcast. This week we're going to talk about how to handle jointly owned assets in probate. Let's just dive right into it. When a loved one passes away, their estate often goes through a process known as probate, the legal procedure for distributing a deceased person's assets. One aspect of this process can particularly be tricky handling joint owned assets. Whether it's jointly owned home, bank account, or investments, these investments may or not pass through probate, depending on the type of ownership and the specific state laws involved. Let's jump into it. Number one, types of jointly owned assets. You got joint tenancy with right of survivorship. This is a type of ownership where two or more people own an asset together. Upon the death of one owner, the surviving owner automatically inherits the deceased property share. Assets typically do not go through probate because the ownership transfers directly to the surviving party. And we have tenants in common. With tenants in common, each owner holds a distinct share of the property, unlike joint tenancy with the right of survivorship. When the owner dies, their share does not automatically pass to the other owners. Instead, the deceased shares become part of the estate and they may need to go through probate depending on whether a will or trust dictates the transfer. Number two, how does joint tenancy with the right of survivorship affects probate? For assets owned under joint tenancy with the right of survivorship, probate is usually not required upon the death of the owner. The surviving owner or owners automatically take full ownership of the property without involving a probate court. Examples of such may be joint bank accounts. Funds in joint account automatically transfer to the surviving account holder. Real estate. If the real estate hold in joint tenancy, the property passes directly to the surviving owners. While this avoids probate process, it's essential to ensure that the joint tenancy agreement is clear and properly executed to prevent any disputes. Number three, handling tenancy in common and probate. When property is owned as tenancy in common, the deceased person's share becomes part of the estate, which is typically subject to probate. In this case, the following steps are usually need to be taken. Valuing the deceased share. The share of the deceased must be appraised and added to the value of the estate for the distribution of the heirs and the beneficiary. 2. Distribution according to the will or state law. If the deceased left a will, their share is distributed according to their wishes. If no will exists, the state entity's law will determine who inherits the share. This process can delay the transfer of ownership and may require the sale of the property if the state lacks liquidity and settles a debt. Number 4, community property. Community property with the right of survivorship. In community property states, spouses may hold assets as community property with the right of survivorship. This means upon the death of one spouse, the surviving spouse automatically inherits the deceased share of community property without probate. However, any separate property owned by one spouse individually may still need to go through the probate. If you reside in a community property state, that can provide an efficient way to pass your estates to your spouse without the involvement of probate courts. Number 5, jointly owned bank accounts. When a person passes away with a jointly owned bank account, the account's funds usually transfer automatically to the surviving owner. However, it's important to note that if the account was used only for convenience, example, someone added as account holder to assist with bill payments, the funds may still need to go through probate depending on the state laws and intention of the deceased. To avoid confusion, it's a good idea to specify ownership intent of joint accounts before they arise. Number 6, the importance of proper estate planning. Joint owned assets can complicate probate if not structured correctly. To avoid confusion, disputes, or unintended consequences, it's essential to work with a estate planning attorney who can help you determine the best way to hold your ownership of assets. Some things to consider include review ownership designations regularly, consider using a revocable trust, Communicate with co-owners. And as we wrap up and give you a summary, handling joint assets and probate can be complex, but understanding the different types of ownership and how they are tested by the law is avoiding unnecessary complications. Joint tenancy with right of survivorship can help avoid probate, while tenants in common may require probate to distribute to the decedent's share. At Dorsey International Realty, we specialize in guiding families through the probate process and ensuring that their real estate assets are handled smoothly and efficiently. If you have any questions about jointly owned assets or how to structure your estate, we're here to help. Thanks for listening to another episode of Dorsey's International Real Estate Podcast. Don't forget to like, subscribe, and comment. Stay connected off the show by visiting Dorsey'sRealty.com. Local expertise, global presence. Your resource for all things probate, estate, and trust in the title.